everyone, myself Jatin Sapra, and today Law Wallah brings you the capsule of execution, suits in particular cases, rules and miscellaneous of sections of CPC. Without wasting any further time, I'll be starting with this video, starting with the execution. Starting with the plan of daily target, that is execution, suits in particular cases, and rules and miscellaneous. Next we will be starting with the topic of execution. So execution देख लेते हैं. Execution is governed under CPC from section 36 to section 71. Sorry, section 74. Please remember this. Section 36 to section 74 and order 21. And order 21. Right? Now, meaning of execution. Meaning. The meaning of execution is enforcement of decree or an order passed by the competent court. Enforcement of order or decree by court. Now, this is the simple meaning of execution. Coming to the next is courts by which decree can be executed. Courts by which decree can be executed. Decree can be executed. There are two types of court by which decree can be executed. First is the trial court, the court which has given the judgment, that is court of first instance. Second, court of appellate. If trial court has passed an order and the appellate court has modified it, right? So तो उसका जो रहेगा वो फर्स्ट इंस्टांस पे ट्रायल कोर्ट ही करेगा अगर वो अपील में चेंज हो गया है. फॉर एग्जांपल अगर अपील में कुछ अलग ही आ गया है तो देन it will be court of first instance in case of appellate cases. Court of first instance in appellate cases. All right, now we will start with the same कि क्या क्या हमारे पास objections या क्या क्या हमारे पास मुश्किलें आ सकती हैं when we go for execution of a decree, right? So many a times क्या होता है, जैसे a suit is filed in Delhi or UP. now जिस प्रॉपर्टी के लिए फाइल हुआ है, जिस क्लेम के लिए फाइल हुआ है, वो वहां नहीं है. फॉर एग्जाम्पल मेरे पास अगर आप ए ने बी से 10 लाख रुपए लेने थे यूपी में और 10 लाख का डिक्री उसके ए के फेवर में चला गया. नाउ हाउ विल ही रियलाइज और हाउ विल ही गेट द फ्रूट ऑफ हिज डिक्री? वो कैसे करेगा? अब वो बोलेगा जज को कि अटैच हिज प्रॉपर्टी, और प्रॉपर्टी यूपी में सिचुएट नहीं है. तो उस सिचुएशन में डिक्री होल्डर के पास क्या रेमेडीज हैं हम वो देख लेते हैं. The option for us is transfer of decree. We can get the decree transferred from one competent court to another competent court. तो ये देख लेते हैं. Transfer of decree. All right. Transfer of decree. Where जेडी, जेडी इज जजमेंट डेटर, मतलब जिसके खिलाफ जजमेंट आई है, resides or works for gain. सेकंड, जहां पे जेडी के पास प्रॉपर्टी इतनी है ताकि उससे डिक्रीटल अमाउंट रिकवर कर सके, वेयर जेडी हैज sufficient property. Third is where property situates, that is directed to be sold. See, always remember when a court in UP has given a judgment or a decree, then either the decree holder can file the execution in the UP jurisdiction, but if the property doesn't situate or he cannot have fruits of the favorable decree in UP, then definitely he has some other remedies. So he can get the decree transferred to where the judgment debtor resides or works for gain, where he has a sufficient property to give the fruits to the decree holder, or the court has given an order of attachment or selling of decree. Then if that property situated in see Kolkata, then a decree can be transferred to the Kolkata to realize its fruit. Next is this all is given under section 39. This is section 39, and this is discretionary power of the court. Discretionary power of the court. This power transfer of decree is not directory or mandatory, but it is a discretionary power. कोर्ट की मर्जी है अगर वो करना चाहे या ना करना चाहे, right? Now we will see what decrees can be executed by Indian courts. Types of decree Indian courts can execute. ठीक है, सबसे पहले इंडियन डिक्री, जो भी इंडियन कोर्ट की डिक्री है, डिक्री ऑफ इंडियन कोर्ट्स. नाउ decree of courts outside territorial jurisdiction of India, but established by the central government of India. But established by the central government. Next shall be revenue courts in India. Now, last and final most is execution in foreign territories of decree passed in Indian courts. For example, if a person has a property in Singapore or Switzerland, then and the decree has been passed by an Indian court, then the decree can be executed by the Indian courts. All right. So next shall be modes of execution. Modes of execution means how a court can help the decree holder in getting the fruits of the decree. Modes of execution. First, डेफिनेटली आपको अगर पैसा रिकवर करना है तो आप कैसे कर सकते हैं? बाय अटैचमेंट ऑफ प्रॉपर्टी ऑफ बाय अटैचमेंट ऑफ प्रॉपर्टी ऑफ जेडी. Second, by delivery of property. Delivery of property means मतलब अगर पैसे रिकवर करने हैं तो पैसे देके, या फिर अगर प्रॉपर्टी का पोजेशन देना है तो पोजेशन देके, राइट. थर्ड इज बाय अरेस्ट ऑफ द जेडी. फोर्थ इज बाय अपॉइंटिंग अ रिसीवर. ऑलराइट, नाउ स्पेशल केसेस देख लेते हैं. पार्टीशन. अगर पार्टीशन डिग्री एग्जीक्यूट कराना है, देन अ कमिश्नर शैल बी अपॉइंटेड. This is section 54. All right. Now I'll be explaining each and every concept to you through the MCQs. Let's start with the MCQs now. Now, the principle governing execution of decree and orders in CPC are dealt within, I've already told you, that is section 36 to 74 and order 21. And it is said order 21 substantive and order 21 provisions, then in A and B. So the answer to this is A, that is procedural provisions. Again, I have already told you that when there is जो procedural होता है, helps in enforcement. Procedural law helps in enforcement. And I have already told you that execution is enforcement of order. So the answer is helps in enforcement, option A, section 36 to 74. Next shall be the expression court which passed the decree is defined under the section of civil procedure. That is, it is a straight and simple question stating what to do and what not to do. So the answer to this is clear, 37 C. Next shall be a decree may be executed under civil procedure code by a collector, sub-collector, tehsildar and the court which passed the decree. Collector, in case of, in exceptional cases, collector can interfere or not, but at the end of the day, it is the court which passed the decree and it directs, right? You will file. ऑलराइट, जो फाइलिंग होगी वो हमेशा कोर्ट ऑफ फर्स्ट इंस्टेंस पे ही रहेगी, कलेक्टर, सब कलेक्टर, तहसीलदार के पास आप डायरेक्टली नहीं जा सकते। So next is a decree may be executed by a district judge, commissioner, court which has passed the decree, either by the court which has passed the decree or to which the decree is sent for the execution. The answer to this is clear, that is D. Next shall be fifth. The application is placed before the following court for the execution of decree. Before district court, before that court which has passed the decree, before that court where the defendant is residing temporarily under local jurisdiction, before that court where the execution property is available under local jurisdiction. Now, I have already told you the option after the court has passed its decree and it cannot do anything, then your decree can be transferred until and unless the remedy avails in the territorial jurisdiction of the court that has passed the decree that has the original execution power. So the application is placed before the court which has passed the decree. That is option number B. Next, transfers can be done. All right. Next, sixth, a decree for execution cannot be sent to a court outside India established by the authority of central government. Yes, it cannot be sent. Foreign court. A foreign court, you cannot send a decree for execution to a foreign court. I've already told you that in India, execution can be done possible in short in courts of Indian origin. Next, the application for execution of decree may be transferred from one court to another court if the party feels that there is a possibility of delay in justice on part of the court if the defendant lives or does business in the jurisdiction of that court where the application for execution of decree have to transfer, if the plaintiff has gone from the jurisdiction of the court which has passed the decree. Now the option that is clear and factual is option number B, that is if the defendant lives or does business in the jurisdiction of that court where the application for the execution of decree have to transfer. So the answer to this is B. Next, court not competent to execute the decree, court which has passed the decree, court to which it has sent for execution, both A and B, court of collector. Obviously, court of collector is the incompetent court and hence the right answer to this question. Again, which has passed a decree, it has the jurisdiction for which it has sent for execution. It is like transfer of decree. C, both A and B not an option. D is court of collector. Except court, no one has the power to directly execute the decree. It can be referred to them by the option in the discretionary power of the court. Now, provisions of section 39 of CPC are permissive and not mandatory, mandatory and not permissible, mandatory and discretionary, none of the above. The answer to this is permissive and not mandatory. See, I already told you provisions of section 39 are discretionary powers. So, it is allowed. Permissive matlab it is allowed but not mandatory. ठीक है? Next, 10th, where a decree is to be sent to a court in another state for execution, it has to be sent by the High Court, the District Court, the court which passed the decree, the court which passed the decree with the consent of the High Court. So the answer to this is the court which has passed the decree. Right? The court which has passed the decree will transfer to the competent court which has jurisdiction in other state. Next, which of the following statement is correct? The court which passed the decree may transfer it to another competent court if the judgment debtor carries on the business within the jurisdiction of the latter court. It is correct. Judgment debtor has no property within the jurisdiction of the former court sufficient to satisfy such decree, but has property within the jurisdiction of the later court. Sufficient to satisfy. It is also correct. Decree directs the sale of immovable property situated outside the local jurisdiction of the former court. The answer is all of these. Right. When there is no decree and the court's hands are tied to uh, go for the execution, then it can transfer in all these circumstances if judgment debtor resides or works for gain in some other टेरिटोरियल जुरिस्डिक्शन और जजमेंट डेटर के पास अगर यूपी की डिग्री है, यूपी में इतना लैंड या इतना प्रॉपर्टी नहीं है ताकि वो 10 लाख रुपए पे कर सके, तो जहां उसके पास प्रॉपर्टी है वहां पे वो कंपिटेंट कोर्ट और कंपिटेंट जुरिस्डिक्शन में ट्रांसफर कर दिया जाएगा. थर्ड कैन बी, अगर यूपी की कोर्ट बोलती है कि जी कलकत्ता में जो आपकी प्रॉपर्टी उसे बेचो, या पार्टीशन के टाइम पे उसे कहते हैं कि उसे ऑक्शन करो, देन ऑल्सो इट विल गो टू दी कंपिटेंट जुरिस्डिक्शन. Now, next, a court to which decree has been transferred for execution cannot, while executing, order attachment, execute the decree against the legal representative of the deceased judgment debtor, send the decree for execution to another court, order execution at the instance of the transferee of the decree. See, it can order attachment. Yes, it has the power. Second is legal representative against. Yes. Now C is send the decree for execution to another court. Yes. So with the elimination, I have reached to 12th. Option D. Next, 13. Words competent jurisdiction under section 39 of CPC refers to pecuniary jurisdiction of the transferee court, territorial jurisdiction of the transferee court, pecuniary and territorial jurisdiction of the transferee court, or none of the above. It refers to pecuniary as well as territorial jurisdiction of the transferee court. So, competent jurisdiction का मतलब देखो, see what happens is the court, this is the technical point of the court. When you file a plaint, the facts of the facts of in issue are the facts that won't change, but you have to actually go and represent yourself in front of a competent court. Now, competent court includes, it should have pecuniary jurisdiction, it should have territorial jurisdiction. As simple as that. 14. Provision relating to precept is provided in Civil Procedure Code under section 46. Now, the concept of precept. Now, precept is order or direction to attach property to another court of competent jurisdiction to attach property. इसमें क्या होता है, फॉर एग्जाम्पल अगर यूपी में डिग्री पास हुआ, राइट, नाउ द judgment debtor has a property in Delhi. So the court in UP can order the competent court in Delhi to attach the property of the judgment debtor in Delhi in interim. मतलब in interim. The most important point is in interim. This is an interim order. Life of this interim order is only 2 months. 2 मंथ से ज्यादा प्रिसेप्ट नहीं रहेगा, प्रिसेप्ट ऑर्डर नहीं रहेगा 2 महीने से ज्यादा के लिए। 2 महीने तक ही उसको अटैच किया जा सकता है फॉर बेयरिंग द फ्रूट्स। सो इंटरिम ऑर्डर लाइफ is equal to 2 months. This is the meaning of precept. Next, precept means command, order, writ, all above. This is an order. 16th. Now, 16th is as per section 46 of Code of Civil Procedure, that is precept. Precept 1908, the precept means an order issued by the court which passed the decree and addressed to the district collector to effect the partition of property, another court to arrest the judgment debtor, the other court to attach the property of the judgment debtor specified in the precept, the revenue court C. The answer is C. Why C? Because the precept in itself, it means that the other court, the later court is ordered to attach the property of the judgment debtor. Next, an order of direction given by the court which passed the decree to a court which would be competent to execute the decree to attach any property belonging to the judgment debtor is called precept, garnishee order, interlocutory order, or simultaneous execution. The answer to this is definitely precept. I have already explained you the meaning of precept in my previous slides. Next, precepts are issued under section 46 CPC for serving summons on person residing beyond local jurisdiction, serving a warrant on the judgment debtor, attaching the property of judgment debtor, or none of the above. The answer is C. As simple as that. 19th, which provision deals with the determination of question relating to discharge, satisfaction, etc. of the decree? Section 48 of the CPC, 46 of the CPC, 47 of the CPC, and 21 of the CPC. Now, the question says determination of question relating to discharge and satisfaction, that is section 47. 20th. Now, 20th is under section 47 of the Code of Civil Procedure, which question does not relate to the execution, discharge, or satisfaction of decree? Whether a decree is executable? Yes, this is being asked. Whether the property is liable to be sold in execution of decree? Yes. Whether the decree is fully satisfied? Yes. Whether decree is fraudulent or collusive? Now, when an execution application is filed in a court of first instance, then the court will not look into the merits of the case and merely will look at the decision or decree only. The court will not see its merits. The court will not see whether it's fraudulent or collusive. The court will close its eyes and will definitely say that the decree has been passed against you. I am the executing court. I will not look into the correctness of the decree. All right. So answer is D. Next, an executing court cannot determine the questions relating to which of the following: execution of decree, discharge of decree, satisfaction of decree, or modification of decree? The answer to this is modification of decree. ठीक है, कोर्ट क्वेश्चंस ये देख सकती है, क्या डिक्री एग्जीक्यूटेबल है, डिस्चार्ज हो सकती है यहाँ पे, मतलब प्रॉपर्टी जो भी है उसका, उसके पास प्रॉपर्टी से फंड्स है कि नहीं, मतलब वो फ्रूट्स देगी कि नहीं, सेटिस्फैक्शन ऑफ डिक्री, अगेन इट कैन बी डन और नॉट, ये तीन चीजें वो देख सकती है। चौथी जो मॉडिफिकेशन ऑफ डिक्री है, द एग्जीक्यूटिंग कोर्ट कैन नॉट मॉडिफाई द डिक्री। Now, questions that can be determined by the court executing the decrees relating to execution alone, relating to discharge alone, relating to part payment alone, now relating to execution, discharge or satisfaction of the court. Now the 22nd answer is all relating to execution, discharge and definitely satisfaction. So the answer to this is D. Next, during proceedings for execution of a decree, if a question arises as to whether any person is or is not the representative of a party, such question shall be determined by the court which passed the decree, the court executing the decree, the appellate court, or a separate suit is to be filed. Now, this has to be determined by the court executing the decree. Next, where a judgment debtor dies before the decree has been fully satisfied, means it is pending execution. So the same cannot be executed against the legal representative. The same can be executed against anyone of the legal representatives of the judgment debtor in its entity. The same can be executed against all the legal representatives. The same can be executed against any number of the legal representatives as the decree holder wants. So it will be executed against all the legal representatives. The clear फंडा ऑफ फैमिली लॉ स्टेट्स कि अगर आपके पास एसेट्स आ रहे हैं आपके फादर के, आपके मदर के, सो उसके साथ आप उनकी राइट्स और लाइबिलिटीज दोनों लेके जाओगे, जितना आपको राइट उतना आपको लाइबिलिटी है, सो ऑल द लीगल रिप्रेजेंटेटिव्स शैल बी लायबल फॉर द सेम. Next shall be an ex parte decree passed by Court A was transferred to Court B for exaction and execution proceedings are pending in Court B. Court A sets aside the ex parte decree on rehearing, and on rehearing a fresh decree was passed on the same terms. So the answer to this is D, because the execution proceedings that has been filed first are null and void now, because the same has been overturned, the decree has been overturned by the competent court. Now a fresh execution petition has to be filed when the final decree will be passed. Next, which of the following is the true meaning of the term legal representative under the Code of Civil Procedure? Now, a person who in law represents the estate of a deceased person, any person who intermeddles with the estate of the deceased, and where a party sues in representative character the person on whom the estate devolves on the death of a party so suing, any person who intermeddles with the estate of the deceased and where a party is sued in a representative character, the person on whom the estate devolves on the death of a party so sued, and all of the above. Let's see. लीगल रिप्रेजेंटेटिव का मतलब ये है, exact, it is correct, any person intermeddles with the state of the deceased and where the party sues in a representative character, it is correct. Any person who intermeddles with the state of the deceased and where the party sued as in a representative person to whom, see, all of the above. Reason being, again, whatever assets you derive, you also derive the liabilities and you are also the legal representative in that sense also. Now next, under section 51 of CPC, which one is not a method to enforce the execution of the decree? By appointing a receiver, we can. By sale without attachment, we can. By arrest and detention, we can. And by appointing a commission. This is not the method to enforce the decree. Next, in which of the following ways can court not order execution of a decree as per section 51 of the code? Now, in this, by delivery of any property specifically decreed, yes, delivery of any property is an option. By attachment and sale of property is an option. By serving summons on the party, by appointing a receiver, this is an option. See, the object of execution is to get the fruits and not to call the other party. So by serving on the summons to the party is not an option. Next, arrest of a person in execution of a decree has been provided under section 53, 54, 55 and 56. The answer to this is 55. Next, the court cannot order execution of a decree as per section 51 of Civil Procedure Code in which of the following ways? By attachment and sale of property, it can be done. A decree for restitution of conjugal rights by sending the person, husband or wife, as the case may be, to the civil prison. By appointing a receiver. The answer to this is definitely is 30th, is B. Now, 31st, which section of Civil Procedure Code prohibits arrest or detention of women in the execution of decree for money? That is section 56. 32. Decree for payment of money passed against a woman cannot be executed by proceeding against a legal representative if she dies, by attachment and sale of a property, by appointing a receiver, and by her arrest and detention in prison. This is the option. This is the answer to the question. The woman cannot be arrested in a case of money. Next, under the Code of Civil Procedure 1908, no woman shall be arrested and detained in civil prison in the matter regarding to the decree relates to family disputes, matrimonial disputes, legitimacy of children disputes, and payment of money disputes. The answer to this is payment of money disputes. 33, 34. Now, section 56 of the Civil Procedure Code specifically prohibits the arrest or detention in civil prison in execution in a decree of a sick person, minor person, a woman, or all of the above. The answer to this is a woman. 35th, on which one of the following grounds under Civil Procedure Code 1908 a warrant of arrest against the judgment debtor may be cancelled by the court? Now, this is serious illness, appearance in marriage of his son, to cast vote in general elections, and none of the above. The answer is serious illness. That is a humanitarian ground. 36. Under section 58 of CPC, a person detained shall be released from the detention on the amount mentioned in the warrant of his detention being paid to the officer appointed by the court, the officer in charge of the civil prison, and none of the above. The answer to this is C, the officer in charge of civil prison. 37. Where the decree is for the payment of sum of money exceeding 5,000 rupees, the period of civil prison shall not exceed 3 months, 6 months, 9 months, or 1 year. The answer to this is 3 months. Now, next question is, according to section 58 of the Code of Civil Procedure, no detention in civil imprisonment can be ordered if the decree is for a payment of amount not exceeding 500, 1000, 1500 या 2000. The answer to this is not exceeding rupees 2000. Next, 39. Where a judgment debtor has been committed to the civil prison, he may be released therefrom by the state government on the ground of the existing of infectious disease, by the committing court or any court to which that court is subordinate on ground of serious illness, by the state government on the ground of the existing of any contagious disease or all of the above. The answer to this is all of the above, because every option has infectious disease and this is an emergent ground. So the answer to this is all of the above. It has infectious disease, serious illness and contagious disease. 40th, a judgment debtor is arrested in execution of a decree for the payment of money, and the judgment debtor pays the amount of the decree and the cost of the arrest to the officer arresting him. Such officer shall send the judgment debtor to civil prison, shall take judgment debtor to the court, shall at once release him, shall release him after taking security for him. Answer to this is shall at once release him. जैसे ही वो सिविल प्रिजन ऑफिसर को वो अपना डिक्री अमाउंट और कॉस्ट पे कर देगा, वैसे ही कोर्ट, नॉट कोर्ट, द सिविल प्रिजन ऑफिसर विल रिलीज. Now 41st, under section 60 of civil procedure code, which of the following properties is not liable to attachment and sale in execution of a decree? The answer to this is negotiable instrument, houses or other buildings, government securities, any right of personal services. So negotiable instrument can be there, houses can be there, government securities can be there. So the answer to this is 41, it's D. Next, under civil procedure code 1908, which one of the properties cannot be attached in execution of a decree? Books of account, land, bank notes or checks. Answer to this is books of accounts. Next, which one of the following properties is liable to attachment and sale in the execution of decree? Right to future maintenance, promissory note, books of account, rights of person service. So is जो previous question were there, so they asked that are not capable. Not capable is right of personal services, not capable, right? Books of accounts not capable. So this is not the answer, this is not the answer. Now you have to see right to future maintenance cannot be attached because you do not know what will happen, and a promissory note, that is a kind of security, that is promissory note can be attached. 44, under CPC, which one of the following is liable to attachment and sale in execution of a decree? Necessary wearing apparel, promissory notes, tools of artisan, books of accounts. The answer to this is again promissory notes. I have added all the questions and their different options so that it will be clear to you that what can be attached and what cannot be attached. 45. Which of the following properties cannot be attached in execution of a decree? Pensions, promissory notes, house or other building, or a hundi? Then this answer is 45 is A. Pensions cannot be attached. A hundi is a security, it's an instrument, it's a money instrument like check. Now books of account are liable to attachment, no. Are no evidence in law, can be the sole evidence to know. Are not liable to attachment and sale in execution of a decree. See, books of accounts cannot be attached. Next, 47th. Which of the following properties are liable to attachment and sale in execution of a decree under section 60 of the civil procedure code? Now they are liable to be attached. Banknotes, checks, and bills of exchange. Yes, this is the correct answer. Stipends and gratuity. No. Cooking vessels. No. Books of accounts. No. So answer is banknotes, checks, and bills of exchange. 47. 48. Whether necessary wearing apparel are liable for attachment in execution of a decree? No. Next, 49. In execution of a decree for the maintenance, salary of a person can be attached to the extent of 1/4, 1/3, 2/3, or 1/2. The answer is 2/3. 50th, which of the following properties of a judgment debtor are liable to be attached? Personal ornaments of religious usage of a woman, tools of artisan, cattle and seed grains, books of accounts, shares in a corporation and government security. The answer to this is clearly shares in a corporation and government securities. Next shall be, which of the following property is not liable to be attached and sold in the execution of a decree? Money, hundis, electricity, none of them is not liable to. Not liable is electricity. You cannot attach electricity. Right. So 51 is C. 52. Properties that can be attached are money, bank notes, checks, bills of exchange, hundis, promissory notes. This is the correct answer. Next, which one of the following properties are liable to attachment or sale in the execution of a decree under Code of Civil Procedure? Are liable for attachment: mere right to sue for damages, a promissory note, books of account, a right of person, a promissory note. See, what can be attached should not be personal, मतलब आपका हवा में नहीं होना चाहिए वो, it should be existing and should be secured. 54. How much salary of a person can be attached in execution of decree for maintenance? First, 1000 rupees and 1/3 of the remainder. First, 1000 rupees and 2/3 of the remainder, 2/3 of the salary, or 1/3 of the salary. The answer to this is again 2/3 of the salary. I have added this question because there can be multiple answers, multiple options that can be there in your judicial examination. So, which of the following kinds of property is not liable to attachment and sale in execution of decree? Money, shares, land, personal. Again, personal, जो personal है, that cannot be there in the attachment and sale in execution of a decree. 56. Private alienation of property after attachment of the same is voidable at the option of the decree holder, voidable at the option of judgment debtor, void ab initio, and void as against all claims enforceable under the attachment. The private alienation of property is void as against all claims. Next, where immovable property is sold in execution of a decree and such sale has become absolute, the property shall be deemed to have vested in the purchaser from the time when the sale becomes absolute, when the property is sold, when the purchaser acquires possession and depends on the court. The answer to this is when the property is sold. See, when the property is sold, then the sale has become absolute and then it will be deemed to have been vested in the purchaser. Next, which of the following person may not file an application for execution under this Code of Civil Procedure? Now, who can file it? A decree holder himself, right? His legal representative, a person claiming under decree, only. A judgment debtor cannot file for execution. So the answer to this is judgment debtor. 59. A money decree may be executed by the attachment and sale of any property of the judgment, arrest and detention in prison of the judgment debtor for indefinite period, both A and B, neither A and B. The answer to this is A. Attachment and sale of any property of the judgment debtor. Next, where decree is of the partition of an undivided estate assessed to payment of revenue to the government, the partition of the estate in accordance with the law for the time being in force shall be made by the collector. I have already told you that in case of partition collectors, the power is vests with the collector. Now, next, I have explained you all the important concepts relating to execution and MCQs I have dealt in. Now the turn comes in suits in particular cases. I'll start with the concept of suits in particular cases and we'll deal with the important MCQs and concept of the same. Now, suits in particular cases. Suits in particular cases. It states that the CPC provides for some conditions before you file a civil suit against some types of suits. Now I'll be discussing that. First is if suit involves interpretation of Constitution of India of Constitution of India. So if there is interpretation of Constitution of India and it is a central government matter, then Attorney General is to be made a party, right? Attorney General party, right? If the matter relates to state government, then Advocate General, right? Now, this is given in Order 27A, right? Order 27A. Now, second is suits involving aliens or foreign rulers, suits against or by aliens, foreign rulers, etc. Suits by or against foreign rulers or aliens, etc. Then this is given under section 83 to 87B. Third, suits by or against soldiers, sailors, or airmen. Suits by or against soldiers, sailors, or airmen. It states that they can authorize any one of them or anyone to represent them in court. All right. So the next is fourth is suits by or against corporations. This means if a suit is by or against corporation, then anyone of the directors, principal officer, or secretary can sign. All right. Now I will be moving on the next, that is doctrine of Cyprus. Doctrine of Cyprus means that the court can draft a scheme that is as nearly as possible to the procedure. Landmark case law is Ratilal versus State of Bombay. Versus State of Bombay, AIR 1954. It is AIR 1954. Now, next is suits by or against government. Suits by or against. Suits or by Suits by or against government, it's if the suit is against central government. Then party will be Union of India. All right. If against state government, then party would be respective state. Like if the party is the case is against the state of Bombay, then the state will be state of Maharashtra, not state of Bombay, but state of Maharashtra. And if the state government is of West Bengal, then state of West Bengal. Respective state. All right. Now, what are the essentials and what should be done if the case is against a state? This is section 79. All right. Now, section 80. This is notice. This is section 80. Now, when you are proceeding against a state or Union of India, you have to give a notice that is under section 80, giving out the names, descriptions of yourself, the cause of action and the relief claimed. So this is a condition precedent. मतलब अगर आपने नोटिस नहीं भेजा है स्टेट को पार्टी बनाने से पहले, then your suit is not valid or can be said null and void. So except in exceptional circumstances where you plead before the court for exemption, right? So it is a condition precedent, right? Condition precedent. अब इसका essentials देख लेते हैं. First essential is name, description and place of plaintiff. Name, description and resident of plaintiff. Second, cause of action. Third is relief claimed. ठीक है. सेक्शन इसका life is 2 months. So whenever you plead central government or state government as party, then you have to give a notice under section 80 of CPC, giving name, description and resident of yourself, cause of action as to why are you approaching them and why will you approach the court, and third, that is the relief claimed. This is to be sent for 2 months prior, that is मतलब 2 महीने का टाइम आप गवर्नमेंट्स को देंगे रिप्लाई करने के लिए, and this is a conditional precedent. This is what section 80 says. Next shall be the MCQs. I'll start with the important MCQs and concepts of suits in particular cases, starting with question number 1. The stipulation that in a suit by the central government, the authority to be named as plaintiff shall be the Union of India has been provided for in section 78, 79, 79A or 77. I've already told you answer to this is 79. 79. Next shall be as provided in section 79 of the Code of Civil Procedure. A suit by the central government must be filed in the name of President of India, Attorney General of India, Prime Minister of India, or Union of India. Answer to this is Union of India. Third, for instituting a suit against the government or against a public officer in official capacity, the notice period under section 80 of CPC is 2 months. I've already told you the answer, that it's 2 months. Now, under which section of CPC a notice is required to be given at least 2 months before filing a suit against the central or state government, that is section 80. See, the notice is given to state government or central government or public officer also. Public officer also, right? Next, which of the following statements is correct? No suit not involving urgent or immediate relief may be instituted against the central government except after serving a notice of 2 months. A decree against the Union of India may not be executed unless it remains unsatisfied for a period of 3 months. Both A and B are correct and both A and B are incorrect. In this situation, See, no suit not involving urgent. So that means it is a normal simple suit. So if there is an urgency, I have already told there is an exception to section number 80. Notice that if there is urgency, then you can dispense with the service of notice of 2 months and you can directly approach the honorable court. Now, no suit not involving urgent or immediate relief means it is a simple suit, then it cannot be instituted. So this is the option, this is right. A decree against the Union of India may not be executed unless it remains unsatisfied for a period of 3 months. It's correct. So the answer to this is both A and B are correct. Next, in a suit which relates to a railway, the authority to be named as plaintiff or defendant shall be the general manager of the railway, a secretary to the central government, the collector of the district, or the Union of India. Now, the ministry, I would say the ministry is been named in this matter. So the answer is the general manager of the railway. 7. Provisions of section 80 of the Civil Procedure Code are mandatory, directory, discretionary, and none. They are mandatory. 8th, which one of the following is a true statement in relation to section 80 of Civil Procedure Code? A suit without service of notice can be instituted generally with the leave of the court. Not generally. It is not generally. So this is wrong. A suit without service of notice can be instituted in cases of urgent or immediate relief with the leave of the court. This is correct. In cases of urgent or immediate relief where leave to institute the suit without service of notice has been granted, interim or otherwise ex parte relief can be granted. No. This interim, even if the service of notice is dispensed with of 2 months, then also the decree won't be passed or interim relief won't be given after giving an opportunity to the opposite party, in this case the government. So this is wrong. Last is no suit under section 80 can be instituted without the compliance of the requirement of notice. No suit means if there is urgency, it can be there. So this is also wrong. The answer to this is B. Right? The answer to this is B. Next, notice under section 80 of the Code of Civil Procedure is mandatory when the suit is against a cooperative society, the suit is against the government, the suit is against Gram Panchayat, the suit is against municipal corporation. The answer to this is government. Next, provision of section 80 of CPC are binding on a court of civil judge, district judge, high court, or all of the above. This is all of the above. Right? Every court is bound by that section and it doesn't discriminate in the system of courts. Next, what does section 80 CPC deal with? CPC deal with foreign judgment? No. Injunction? No. Requirement of a notice for a institution of suit against government? Yes. Next, a notice in writing under section 80 of the Civil Procedure Code has to be given to the secretary to the central government in case of suit against the government, President of India in case of suit against the central government, Secretary of Railways in case of suit against the central government involving railways. It should be Secretary of Railways, Secretary to the central case of, yes, Secretary, yes, A is correct, C is correct, answer is A and C both. Because the secretary is to be made the part, government is made the party through secretary. So there should be a legal natural person or living person who will be representing them in court, that is the secretary. See, if you have any doubts regarding the MCQs I'm dealing in, you can definitely ask your doubts in the comment section below. Now, where a decree is passed against the Union of India or a state for the act done in the official capacity of the officer concerned under section 82 CPC, execution shall not be issued on any such decree unless the decree remains unsatisfied for a period of 3 months. We have already dealt with this. The answer is 3 months. Next, now in a suit against the state government, who may sign the plaint on behalf of the government? Governor, chief minister, chief secretary, a person who by a general or special order appointed in this behalf by the government. The answer is D. A person who has been appointed by the government to sign the same. All right. Then, under which provision of CPC an ambassador can be sued? Section 86, 88, 88. He cannot be sued. The answer to this is section 86. Next, a person may sue a foreign state with the consent of the state government, only with the consent of central government, with the consent of central or state government, with the consent of the President of India. The answer to this is only with the consent of central government, because a foreign state is involved. Which of the following is true? An alien enemies residing in India can never sue. Alien enemies residing in India may sue with the permission of the central government. Alien enemies residing in India may sue with the permission of the state government in whose jurisdiction they are residing. And or alien enemies can sue in any court. See, can never sue cannot be happen, because again India is based on rights, and so the option to this is 17th is B, because they can sue with the permission of the central. The provision regarding interpleader suit has been incorporated in section 87, 88, 89 and 88. Option to this is 88. I'll explain you the concept of interpleader suit. Now, interpleader suit is where the dispute is between the defendants, where the suit, not suit, but where the dispute is between defendants, right? For example, A is tenant on property of B. A is a tenant on the property of B. Now B expires, leaving behind C his son, D his another son. All right. Now it is clear with the fact that A is the tenant of property of B. B was the landlord, and now C and D are fighting for the property which is being rented out to A. Now what will A do? Now A is clear that he has no objection as to payment of rent. So he has to clearly state in his suit, he will file an interpleader suit. He will say that I am the tenant of property B and I have no objection to give rent to any one of them. So the court has to decide, and in this case C and D are not filing their written statement on the same line. They are fighting within themselves. So the dispute is between defendants only, and C and D are fighting with them. So A has filed because A needs to give his rent. So A files an interpleader suit against C and D, stating, asking the court to decide to whom he shall pay the rent, right? So, all right. So this is an example of interpleader suit. Next, provision relating to interpleader suit are contained in Order 34, Section 88, Order 35, both B and C. The answer to this is both B and C. Next, interpleader suit can be filed when there is a claim against pleader, no advocate. See, agar jab when we read the word interpleader, then automatically it comes to our mind that a pleader means an advocate who is pleading. So this is not the case here. The claim is filed against two or more defendants who have set up rival titles of the property in order to locate real landlord of the tenant. I've given you the same example. The claim is set up is against two or more trespassers in the suit property in suit against two or more indigent person. No. Answer to this is B. The claim is filed against two or more defendants who have set up rival titles to the property in order to locate the real landlord of the tenant. The answer to this is B. Now, for an interpleader suit, which of the following conditions is not necessary? There must be or some debt or the property in dispute, two or more persons claiming the debt or property in dispute adversely to one another, there must be a suit pending within the rights of rival claimants for the debt or the property in dispute can be properly adjudicated, and all of the above. So answer to this is there must be a suit pending, interpleader suit, okay, wherein the rights of rival claimants for the debt or property in dispute can be properly adjudicated. So the answer is C. Next, interpleader suit is a suit between two advocates between union government pleader and state government pleader, instituted by a person who has no interest in the subject matter, instituted by a person who has interest in the subject matter. The answer is instituted by a person who has no interest in the subject matter. Like tenant has no interest in the suit in the property he lives on rent, right? Next, 23rd, A deposits a box of jewels with B as his agent, alleges that the jewels were wrongfully obtained by A from him and claims them from B. There B can institute interpleader suit against A, can institute interpleader suit against C, can institute interpleader suit against A and C. Both cannot institute an interpleader suit against A and C. Cannot institute. Interpleader तो होता है जिसमें आपका वो नहीं होता, right? A deposited a box of jewel with B as his agent. Jewels were wrongfully obtained by A. Huh. Yes. All right. So next, Section 89 of the present code of the civil procedure deals with which one of the following: appointment of receiver, interpleader suit, settlement of disputes outside the court, and cancellation of decree. That is, Section 89 is settlement of disputes outside the court. Now, provision of settlement of dispute outside the court has been provided under Section 89. See, settlement out of court, settlement out of court is first is arbitration, negotiation, mediation, or conciliation. So these were the amendments of the Justice Malimat Committee that says to have the object or to reach out the object of the CPC for fair trial, quick decisions and simple procedure. These were amended or incorporated in the Civil Procedure Code. Now, Section 18(9) of the CPC was inserted in 1993, 1998, 1999 or 2009. The answer to this is 1999. Next, the court under Section 89(1) of the CPC can refer the dispute for mediation or lok adalat, arbitration or conciliation, conciliation or mediation, or all of the above. The answer to this is all of the. मीडिएशन में भेज सकती हैं, आर्बिट्रेशन में भेज सकती हैं, कंसिलेशन मीडिएशन में भी भेज सकती हैं. सो ऑल ऑफ द. 28th, which one of the following modes of settlement of dispute outside the court has not been provided in the Section 89 of the CPC? Arbitration, conciliation, negotiation and mediation. The answer to this is negotiation. Negotiation is not given in the CPC because arbitration जो होता है that is proper, it is a different, it gets a different forum. Conciliation also, there are conciliation cells. For mediation there are also mediation centers. For negotiation, negotiation is a process can be inculcated in mediation only or conciliation only, मतलब माल भोग करना, right? Negotiation is that kind of thing. Or you can just go stand outside and just negotiate the terms and conditions. When you write that, that shall be a mediation settlement or a conciliation settlement. So negotiation is a process. Section 89 of the Code of Civil Procedure 1908 provides that the court shall attempt settlement of disputes in all cases where both parties specifically plead for settlement, in cases where at least one of the parties pleads for settlement, in cases where the court is satisfied that there is a possibility of arriving at a settlement that may be acceptable to both the parties. The answer to this is clear. जहां पे कोर्ट को लगता है वहां पे वो रेफर कर सकती है. So an incident of this, that is when you will start your civil practice or you attend civil courts, the judges are like they want people to settle their matters because they also know the fate. They sometimes know the fate. They tell the parties that please settle the matter because this will not give you any fruits for the next 5, 6, 7, 8, 9, 10 years, right? So कोर्ट इज सेटिस्फाइड, अगर कोर्ट को लगता है कि यहाँ सेटलमेंट के चांसेस हैं या सेटलमेंट हो सकता है या सेटलमेंट बैठ के बात हो जाए तो कुछ बात बन जाए, देन कोर्ट कैन have his powers in motion and refer the matter for mediation. Now, where it appears to the court that there exists element of settlement, the court shall decide the matter itself, refer the same for arbitration, conciliation or mediation. This is the option. This is the correct option. Next, the provision regarding friendly suits are in section 90, section 90, order 36 of the Code of Civil Procedure, section 88, order 35 of CPC, order 34 and order 33. Option is in section 90. Next, suits for declaration and injunction in respect of public nuisances under section 91 can be instituted by an individual without the leave of the court, an individual with the leave of the court, two or more persons without the leave of the court, two or persons with the leave of the court. The answer is two or more persons with the leave of the court. Next, who can file a suit under section 91 of the CPC? For public nuisance, Advocate General, any citizen, District Magistrate, any 10 or more citizens. Answer to this is Advocate General. Next, in the case of a public nuisance, a suit under section 91 of the Code of Civil Procedure for a declaration and injunction may be instituted by a person aggrieved a person to whom special damage has been caused by the reason of such public nuisance. With the leave of the court, two or more persons, even though no special damage has been caused to such person, two or more persons to whom special damage has been caused by reason of such public nuisance. That is, with the leave of the court. See. Next, when where a person commits a public nuisance, he is liable to a criminal prosecution under IPC. Suit may be filed against him under section 91 of CPC. Suit for damages may be filed against him. All of the above. The answer to this is suit may be filed against him under section 91 of the CPC. A suit alleging public nuisance can be instituted by Advocate General of the state, by two or more persons who have suffered the damage, by two or more persons with the leave of the court, even though no special damage has been caused to them, a member of the local body. Which of the combination is correct? The answer to this is A is correct, and two or more persons with the leave of the court. C. Advocate General can do this, and C can also do this. The answer is B. 36 is B. Next, who amongst the following may sue for public nuisance and other wrongful acts affecting the public? A and B both. We all know Advocate General and with the leave of the court. Now A and B both. The answer to this is 37 is D. Then 38. A suit in respect of public charity is provided under section 92 of CPC. This is correct. I already knew this answer. So next is in which of the following sections of the Code of Civil Procedure provisions for suits relating to public charities is found? The answer is 92 and 93. Third, 40th. Which one of the following does not find place under the provisions of section 94 CPC relating to supplemental proceedings? That is, arrest before judgment, arrest before attachment before judgment, temporary injunction, or appointment of executors. Because I've reached to this question because this answer because this by the method of elimination. Arrest of before judgment is there, attachment before judgment is there, temporary injunction is a part of them, but appointment is not. So supplemental and incidental proceedings are stated in CPC, CRPC, Unlawful Activities Prevention Act, or none of the above. The answer to this is CPC. Next, which of the following is not a supplementary proceeding? Grant of temporary injunction, grant appointment of a receiver, direction to defendant to furnish security, and issuance of a commission. The answer to this is issuance of a commission, because जो supplementary proceedings होता है that is temporary injunction, receiver, जब receiver अपॉइंट होता है तब भी होता है, and जब डायरेक्शन दी जाती है किसी को या डिफेंडेंट को सिक्योरिटी फर्निश करने की डायरेक्शन दी जाती है, then also it amounts to supplementary proceeding. Next, which provision of the Code of Civil Procedure 1908 deals with appeal from original degree? That is 96. I will be explaining you this appeal here and here only. Now, appeal. Now, appeal is defined under section 96. Now we can see from which orders or decree appeal is there. First, it is every decree is appealable. Every decree, if not barred, right? Second is ex parte decree is appealable. Third, consent decree, not appealable. Fourth is if the amount is less than 10,000 rupees. then no appeal. This came under amendment of 1999. All right. So next question is, uh, no appeal shall lie from a decree passed by the court with the consent of parties. It is provided under 96 1, 2, 3 or 4, that is 96 clause 3. 44th is C. Next, 45th, section 96 clause 4, the Code of Civil Procedure inserted by the Code of Civil Procedure Amendment Act 96 bars appeal against consent decree, appeal in petty cases, appeal against final decree, appeal against findings, appeal against petty cases. Petty cases means small cases. Next, which of the following statement is correct? An appeal may lie from an original decree passed ex parte. This is correct. No appeal shall lie from a decree passed by the court with the consent. This is also correct. No appeal shall lie on question of law. Appeal lies. This is wrong. So the answer is both A and B. Next, an appeal shall lie from all orders passed by the court only from such orders provided in the Code of Civil Procedure, from none of the orders passed by the district court, from none of the orders passed by the none of the decrees passed by the district court. The answer to this is option B, only from such orders as provided in the Code of Civil Procedure. Because if the orders are not provided in the civil procedure, then they will not amount to orders. It is a self-explanatory answer. 48. Point out the wrong statement. Where the defendant appears and the plaintiff does not appear, when the suit is called for hearing, the court shall dismiss the suit and the plaintiff shall be barred from filing a fresh suit on the same cause of action. No, this is the correct. No appeal may lie from an original decree passed. Appeal lies. This is correct. This is also correct. Let's see the next option. And the plaintiff may apply to the court which passed an ex parte decree against him for an order to set it aside. No court. C. C is also confusing. देखते हैं. Needs consideration. No court shall set aside a decree passed ex parte merely on the ground that there has been an irregularity in the service of someone upon the defendant. जो करना चाहिए, मेरे को सारे ठीक लग रहे हैं. Let's see. Let's go ahead and ask. Point out the wrong statement. Wrong statement. Appeal may lie from an original. Yes, it is. This is the correct option. Because appeal lies from an original decree passed ex parte. So this is the wrong statement. Next is 49. Under which section of the Civil Procedure Code a second appeal can be filed? Now, second appeal is under section 100. This is what I believe. Let's check. 49 is C only. Yes. So what section 100 states? It's second appeal. Second appeal देख लेते हैं. Second appeal is only and only filed on if there exists a substantial question of law. Only and only filed or entertained if there is a substantial question of law, question of law involved. Essential. The party filing the second appeal should mention the substantial question of law involved. Mentioning of substantial question of law involved. All right. So next shall be second appeal under section 100 of Civil Procedure Code lies before District Court, High Court, Supreme Court or Special Court. Now this is something very tricky, but the same lies before the High Court only. Next shall be essential condition provided under section 101 of CPC for preferring second appeal is substantial question of fact, substantial question of law, error regarding jurisdiction, subject matter of public importance, that is B. 51st is B. Under the provisions of Code of Civil Procedure, no second appeal lies in a suit for recovery of money not exceeding 25,000. If the money is less than 25,000, appeal lies, but a second appeal will not lie. 53. 53 is if the appeal is heard by a single judge bench of a high court, where does further appeal lie? Only to the Supreme Court, no further appeal by division bench of high court, by division bench of high court. तो इसका जो हायरार्की है वो ये है कि नीचे से ऊपर की तरफ चलेंगे. सबसे पहले डिस्ट्रिक्ट कोर्ट्स, उसके बाद हाई कोर्ट, सिंगल बेंच और सिंगल जज. ठीक है. नेक्स्ट इसके ऊपर है हाई कोर्ट, डिवीजन बेंच, इसके ऊपर है सुप्रीम कोर्ट. राइट, दिस इज द हायरार्की ऑफ कोर्ट्स इन इंडिया. Next, 54. Under section 100A of the CPC, where any appeal from the original or appellate decree or order is heard and decided by a single judge of a high court, no further appeal shall lie from the judgment and decree of such single judge. Further appeal shall lie under the latest patent for the high court. Further appeal shall lie with the leave of the Supreme Court. Further appeal shall lie before the division bench of the High Court. The answer to this is no further appeal shall lie from the judgment and decree of such single judge. It is specifically for 100A. Next, 55. 55 is in second appeal, the reappreciation of evidence is permissible, subject to revision, not permissible, none of these. तो 55 में अगर आप दोबारा जाते हैं तो इसका रहेगा 55 is second appeal में second appeal and reappreciation. Question of law का है, not permissible because in the second appeal only and only law is to be seen, whether it is applied correctly or not. That's it. 56. Under section 104 of CPC, an appeal can be preferred against an order under section 91 to refuse permission to institute suit, an order under section 95 for compensation, and order under section 92, and all of the above. The answer to this is, this can be done, this can be done, this can also be done. The answer is D, right? All of the above. Which of the following is not the correct regarding the powers of appellate court? Appellate court has power to determine a case. Appellate court has power to remand the case. Yes. Appellate court has no power to take additional evidence. Appellate court has power to frame issue and refer them to trial. C. Appellate can do this. Appellate court can do this. Can do this. Appellate court has power. It has also has power to take additional evidence. Right. So the answer is has power. The answer is C. 58. Which one of the following is correct? Appellate court shall have power to determine a case finally. It is correct. Appellate court shall not remand a case. False. Appellate court shall not have the power to frame. It has power. Appellate court shall not have the power to take it. The answer is A. Because appellate court can adjudicate or determine the case finally. Next, which of the following is not correct regarding powers of appellant court? Have power to remand the case, correct? Have power to take evidence, correct? Not have the power to take additional evidence, have power to frame. Answer is C. Clearly, it's C. Next, an appeal shall not lie from which of the following order under the Code of Civil Procedure? Section 35A, Section 35B, Section 95 and Section 91. So answer is Section 35B. Next, which one of the following combination is mismatched under the Civil Procedure Code? The answer to this is Temporary Injunction Order 39, Right to lodge a caveat Section 148A, Suit by Pauper Order 33, and powers of appellate court is section 102. No, this is the right answer. The powers are not defined in 102. However, this is correct, and this is also correct. Now, with this, I will end your suits in particular cases in CPC. Now, I'll be starting with the topic of rules and miscellaneous sections of the CPC. In this, I will be dealing with the leftover part of the CPC through MCQs and will be explaining the concept if needed in the MCQs only. So let's start with the MCQs directly. Now, starting with the MCQs, which one of the following sections of CPC provides exemption of certain women from personal appearance in the court? Section 133, 135, 135A or 132? Section 132. Next shall be, which among the following is not entitled to exemption from personal appearance in the court? That is former Indian ruler, chairman of the state legislative councils, the minister of states or collector. Answer I have already marked, that is former Indian ruler. Next, the Code of Civil Procedure exempts ministers of state from personal appearance in the court. Might be correct. Does not exempt any person from personal appearance. This is wrong. Exempts advocates. Exempts advocates. No. From personal appearance, no. Exempts municipal commissioners from personal appearance in the court. Might be, but ministers are yes. Most relevant to and closest to the what the answers or the option says, it is the point A. So I'm going with point A, exempts ministers of state from personal appearance in the court. Next, exemptions from personal appearance in court is provided under 133, 132, 143 and or 142. 132 is definitely not. So the answer is A because it is given in section 133. Now, who of the following is exempted from personal appearance from the court? Ministers of union, yes. Ministers of state, yes. Judges of high court, yes. See, judges of High Court, I know because in one of the matters, judge of High Court was summoned and he moved an application for the same, and he was exempted. Then again, next, sixth, which section of the Civil Procedure Code grant exemption to members of legislature from arrest and detention under civil procedure? Answer to this is section 80, 134, 135A or 132. It is an amendment, it is an additional section of section 135A. Next, seventh, affidavits to be filed in a court can be authenticated by a minister of state. Authentic cannot be authenticated except by the judge presiding. Authenticated by a judge, a magistrate, or a notary. Authenticated by an advocate. See, authenticated by a judge, magistrate, or a notary, because affidavits are that are to be filed in a court now are being attested by the notary public. So you have to just see, there was a first a difference between oath commissioner and a notary public. Now oath commissioner, what was the role of oath commissioner is to the affidavits that were filed in courts were to be attested by oath commissioners. Now all other affidavits are to be attested by notary. So in Delhi, I would say, in Delhi the notification came that said that notary public are also eligible, and it is okay for them to attest an affidavit that is to be filed in a court. So this was the recent scenario. So that is why it's C. Next, all orders and notices served on or given to any person under the provisions of Civil Procedure Code shall be in writing, has been provided under section 142, 143, 142 or 144. The answer to this is 142. Does the civil court or trial court have the power of restitution of variation of a decree or order in appeal? Now, trial court of first instance that had passed the decree has the power of restitution. This might be correct. A separate civil suit has to be filed. No. Trial court of first instance that had passed the decree has no power of restitution. It has power of restitution. Thus, there is no power of restitution. No. The answer to this is A. Next, on the reversal of decree, which section imposes an obligation on the party to the suit who received an unjust benefit of the erroneous decree to make restitution of the to the other party for what he has lost? Section 141, 142, 143 or 144. Answer to this is section 144 CPC. See, these all are for your revision and the miscellaneous or the remaining sections that are being asked in your previous year question papers, but they are not that concept handling, but are important from the view of remembering. So I am making you revise through this video the sections and their ingredients, right? Coming to question number 11, which one of the following sections of the Code of Civil Procedure Code 1908 embraces the principle of restitution? 134, 144, 148A or 151? The answer to this is again 144. Next, what is the meaning of restitution? Dispossessing a person in occupation of suit property, re-adjudication of the claim, restoration of the suit, and restoring to a party on the modification, variation, or reversal of a decree. So the answer to this is restoring to a party on the modification, variation, or reversal of a decree. Next, under section 148 of CPC, the court can enlarge the time not exceeding in total 90 days, 60 days, 45 days, or 30 days. 148 time, that is 30 days. Next, question number 14. Time for instituting a suit can be enlarged by invoking which of the following procedures? That is section 151 CPC. This is inherent power. Section 5 of limitation 148 of no. This is not, the option is not there. Now 15th, where any period is fixed or granted by the court for doing an act prescribed by the CPC, the court may enlarge such period not exceeding 90 days in total, not exceeding 30 days in total, not exceeding 60 days in total, not exceeding 120 days in total. So it is 30 days. The answer is 30 days. See, courts are not given any power beyond 30 days, right? So 30 days, the court has the power to adjudicate or to grant time not exceeding 30 days. Next, right to lodge a caveat has been provided under 148, 148A, 148B or 147. The answer to this is 148A. Next question shall be question number 17. The duration of existence of a caveat filed under the Code of Civil Procedure 1908 is 60 days from the date it was filed, 30 days, 120 days or 90 days. The answer is 90 days. Now, why a caveat is filed? Caveat means, for example, A filed a suit against B. ठीक है? B won. ठीक है? Now B anticipates that A will appeal, right? So B in advance will notify the court of appeal that no order shall be passed without his presence. Now, note that this notification, how will he notify? This is caveat. All right. Next, 18th. A caveat under the Code of Civil Procedure 1908 may be lodged when any suit is instituted, proceeding is initiated or instituted, suit is about to be instituted, suit or proceeding is instituted or about to be instituted. The answer to this is 18th. Oh, sorry. The answer to this is D. Suit or proceeding is instituted or about to be instituted. Lodging of caveat under section 148A of CPC entitles the caveat or to receive the notice of the application, makes the caveat or a party to the suit, both A and B, and none of the above. The answer to this is entitles the caveat or to receive the notice of application. जिससे क्या होता है, what is the importance of the caveat is that no proceeding would be conducted in your absence. So if I am the decree holder and the judgment debtor goes to an appeal, I'll be informed first and no decision will be taken or no order will be passed in my absence. 20th, under which section of the Code of Civil Procedure inherent powers of the court has been provided? This is section 151. Section 151 is the most common section used. So what some the what the practice is says that if you're not getting the exact order or section of the relief you are claiming in an application or something like that, you can always file an application under section 151 of CPC that gives inherent power to the court to adjudicate upon the same. But there are ample of judges that say that if a specific order or specific section is available for you for availing your remedy, then you should file in that section or order so that the CPC is followed. Inherent powers may be used by the court for meet ends of justice to prevent abuse of the process of the court, both here A and B above. So this is correct. This is correct. The answer to 21st is C. Next, under section 151 of the CPC, inherent powers can be exercised by the Supreme Court, High Court, District Court, means any court dealing in civil matters. Next, inherent powers conferred under section 151 of the Code of Civil Procedure 1908 may be exercised by the Supreme Court only, High Court only, District Court only. The answer to this is D. 23rd is definitely D. 24th, under the inherent powers of the civil court, it can pass orders to refer the matter to mediator necessary for the ends of the justice to prevent abuse of the process of court, for compelling the parties, for compelling. No, answer this B. 24th is B because inherent powers, see, I have already told you, when there is a specific section for to refer the matter for mediator, then it will be under 89. For compelling the parties, again, the court cannot compel the parties to settle the matter, but can suggest, or whenever it thinks that this matter is liable or can be settled, then the court asks the parties to settle the matter. If they agree, then only the mediation is started or the matter is sent to mediation. Now again, the option D is for compelling a plaintiff. Again, the court will not compel anyone to do anything until unless it is within their powers. So the relevant option is B, necessary for the ends of justice or to prevent abuse of the process of the court. Next, clerical or arithmetical mistakes in judgments, orders, etc. can be corrected under section 152 of CPC, 54 of CPC, 55 of CPC, or 53 of CPC. Answer is 152 of CPC. See, clerical और arithmetical जो mistakes होती हैं, वो क्या होता है, जैसे clerical means was, is, had, have, so it changes the meaning of the sentence, or it is a typing mistake. अगर नाम गलत हो गया है, for example मेरे नाम की spelling गलत है, for example my name is Jatin, so it is typed as Ratin. Sometimes maybe it's Jatin Sapra, so it may be typed as Jatin Sharma. So वो clerical mistakes होती हैं. Arithmetical mistakes होती हैं, that is calculation. For example, an award or recovery of 1 lakh rupees is passed and 10 is omitted or 10 is added, so that can be rectified. Now next, the power of a court to correct clerical or arithmetical mistakes in judgments, decrees, or orders may at any time by the court of its own motion, may at any time be exercised on an application by any of the parties, either A or B. Again, if the court comes to the knowledge that it has committed a mathematical or arithmetical or clerical error, it can rectify the same by on its own motion or by an application moved by the parties. Next, who has right to make an application for amendment of judgments and orders under section 152 CPC? The answer to this is person agreed with permission of the court. any of the parties or government leader. Now, any of the parties in this, everyone is included, aggrieved person also and the other person also, if there is any arithmetical or clerical mistakes. All right. So next is 28th. Section 152 of the CPC empowers the court to amend judgment, decree, or orders in respect of clerical or arithmetical mistakes only, accident, slips, or omission only, A and B both, none of the above. The answer to this is A and B both. Again, if there is an accidental slip or omission, now for example, if there is a claim, there are three issues, right? So the court has not dealt with one issue, so it is assumed that the court is not in favor of granting you that relief. Now how will you explain the court that it is an omission, accidental omission or accidental slip, or the court is not in favor of the same? So you can definitely go for section 152 and ask clarification from the court that whether I have been not granted this relief or whether it is by way of accidental omission or slip. Next, general power to amend any error or defect in any proceedings in a suit vest in the court by virtue of Section 152, 53, 153A or 153B. The answer to this is 153 CPC. Next shall be question number 30. Which of the following deals with the power to amend decree or order where appeal is summarily dismissed in the Code of Civil Procedure? Section 145A, 103A, 148A or 153A. The answer to this is section 153A. Next, which one of the following sections of the Code of Civil Procedure provides for the trial in open courts where public may have access? 153A, B, C or D. The answer to this is section 153B. Next, under the provisions of the Code of Civil Procedure, the court has no inherent jurisdiction to restore a suit dismissed for non-payment of court fees, to restore an election petition dismissed for default, to consolidate suits based on different claims, all of the above. Inherent jurisdiction does not include the power to restore suits that has been dismissed for non-payment of court fees. Example, it is a decree. Now it is a decree. Since it is a decree now, it is an appealable order or appealable decree. The party has to approach the higher courts because the legal remedy available to him is appeal in the higher court. To restore an now, since election petition is dismissed for default, the power of the trial court is finished and it has to go for another remedy. Third, to consolidate suit based on different claims. Again, it is not in the power of the high court, there power of this trial court, it is an exception. Again, these answers all are correct. That is, the answer is all of the above. Next, when proper court fees is not paid by the plaintiff, the court shall reject the plaint, shall grant time to the plaintiff to pay deficient court fees, the court shall send a report to the government, none of them. The answer is shall grant time to the plaintiff to pay deficient court fees. Now, the steps is, if I file a suit of 2 lakhs, right? Court fee rupees XYZ now paid rupees XY, deficit is rupees Z. What will code do? Code will grant time to plaintiff to submit court fee. If after also granting the extra time to the plaintiff fails to deposit the court fees, then the court shall reject the plaint. If not deposited, then reject. All right. So with this, I will end this video. I hope this capsule helps you in your revision quickly for your UP Judiciary examination. In the next video, I will be covering all the topics of orders that are important that I told you in my very first video while I was discussing the plan of UP Judiciary preparation. Thank you so much for this and all the best for your UP Judiciary examinations.